the overlap of contract and tort. And with that, we saw how typically these two areas of obligations can overlap. And we talked about how one of the ways in they'll overlap is where there's professional advice given. So an accountant, if we think about the Deloitte and Touche case, an accountant is hired to undertake an audit, and they miss something. Is that contract or tort, would you say?
So,
Why? What? Sorry, I heard tort first, so why tort?
tort because there's no contract between
No, there would be a contract. If you hire an accountant to perform an audit, there's a contract.
No, I mean between the accountant and the future purchaser for the.
Yeah, well, that's in the Caparo scenario, right? So I'm just saying, in a situation where you have hired an accountant to perform an audit of your company, what area would that engage? Contract or tort or both?
Both, but preferably both, but preferably the tort is better because, like, if, as you said, if the contract is well drafted, so the chance of the plaintiff will be lower than the tort.
Okay, but if it's well drafted, what would usually be in a contract?
Exclusion clause,
Yeah.
or
So an exclusion clause.
Agreement clause or whatever.
Yeah, well, that would be also under the contract. So you have two items or two provisions that you're looking for, and if not two provisions explicitly, then it would be, as we saw last week, something like an entire agreement clause that can function like an exclusion clause. But basically what you're looking at is, has the contract tried to exclude liability for tort? And is there a cap on damages under contract? So if we have an accountant that we think messed up, and they have an exclusion clause, what would be the order of operations? What I mean by that is, if there is an exclusion clause and we think we can sue in tort, can we look at tort first and then go to the exclusion clause, or do we have to look at the exclusion clause to see if we can go to tort?
You have to accept the exclusion clause.
Yeah.
To make sure that the possibility to sue for tort is not limited.
Yeah, or excluded.
Or excluded.
So there is an order of operations here. You have to look at what we might call the contract issue, the exclusion clause, in order to open up the possibility for a tort claim. So this is sort of the typical way we would see the two overlapping. We can see them overlapping in other scenarios as well. If we think about B.G. Checo, that was the landmark case from 1993, the Supreme Court of Canada, that said claimants can sue in both tort and contract concurrently, but they cannot recover in both contract and tort, recover damages. So why was that a tort and a contract case? B.G. Checo. what was happening in BG Checo. Why is it contract and tort? Sorry.
So, Hydro hired Checo to lay power lines, and he had to clear the paths
Yeah.
in order for the other person to get the work done, but
Yeah.
he didn't do that.
Yep.
And the court provided a clause that said that Hydro should clear the path. But that was what it's showing contract, if I didn't.
Yep.
But
So there was a breach of contract
Yes.
because the contract stated BC Hydro would clear a path in the forest for BG Checo to erect power line towers.
And also negligent misrepresentation,
How did that come about?
because he undertook the application to clear the way, and he didn't do that, the negligent, and this caused damage.
Yeah.
Delay.
So, to be clear, BG Checo is saying there's a breach of contract, an express term. And there'd be damages for that. But what are the damages for negligent misrepresentation? And that's what's on the exam. They were walking in.
Precision and damage.
Yeah, so, well, so, yeah, so, and what was the cost of that misrepresentation, so to speak, or the loss for BG Checo in tort? What are they suing for? Because it's clear that if Hydro didn't perform the express term that they were obliged to do, that's clearly a breach of contract. But where does the tort come in, the negligent misrepresentation? As Constantina said, BC Hydro negligently misrepresented that it would clear the path.
And they,
But what's the loss?
because like they, it caused them like to spend more money to clear the path.
Right.
To speed up the process.
So they had to
So
spend
they-
more money
yeah.
just in order to perform their contractual obligations.
Yeah.
If they had known that they would have to clear the path and erect the towers, what would be different? Well,
Right.
BG Checo would factor that into the price that they charged BC Hydro. Because the Hydro said they would have done it, that wasn't factored in. So actually, Checo is, I think they operated at a loss on this. Because just to perform the contract, all this extra work had to be done. Then they did what they were supposed to. So this is an example of contract and tort overlapping where you don't have an exclusion clause. You have a breach of contract, but there's also a loss there, a loss in tort, pure economic loss. So these are two examples of an overlap between contract and tort. And what you're thinking through in these is, I guess, even, let's start, even before you know it's a contract and tort overlap, you're looking at, well, what was lost? What's the damage or the harm here? So thinking about the BG Checo case, we find the harm, so to speak, in contract with the breach, but then we also have this pure economic loss. And that's what tells us that there's contract and tort arguments to be made. And at the early stage, as I said, exams come at the stage that the client is first coming to you with the problem. And asking you for advice, you're saying, well, there could be tort and contract claims. And this is how it might work. And I emphasize that because in an exam, you're not advocating. Presumably, by the time you get to trial, you have answers to all your questions. But in an exam, you don't have that. You might have a situation where you think something's ambiguous. A fact is ambiguous. And what do you do with that? Well, part of an exam is a skill in determining what are the vague facts and putting forward why an answer to them is important. So you're applying the law, but you're also sort of applying an application of the law, and I'll explain that. So if there's a fact that's vague, you're saying, well, if X is what happened, then this is the approach that would be taken. If the fact is Y, then this approach would be taken. So you're outlining for the client not just what law will be applicable, but what further information is needed. And at that first meeting, further information is always needed. But you still, even with vague facts, you can give an idea as to what would happen. So if we step back a bit and just think about using this overlap as an example question, if we think about BG Checo being a fact pattern for an exam, do you know what I mean by fact pattern? Like okay. How do you approach that? I'll tell you how I approached my exams. I always thought law exams were about, if you had 3 questions, it was about 30 minutes, 10 minutes per question. In that 10 minutes, you've read it, assessed and applied the law, and drafted out a plan of how you would answer the question. And how long is your exam?
3 hours.
Okay, so 1 hour per question. So 10 minutes, you're planning, 50 minutes, you're writing or typing. And I put it to you that way because I think it accurately encapsulates what it is that you're preparing for. You're not really preparing for 3 hours. You're preparing for that time where somebody says to you, here's my problem, what do you think? And you're processing everything and providing the advice. That's the 10 minutes that I'm talking about. So if we sort of work backwards, what does that mean? Well, that means you are very fluent with the topics, that you can recognize them based on the facts before you. So if we have BG Checo facts, you can assess, well, I see a contract claim and I see a tort claim, specifically negligent misrepresentation. Here's what are the tests, here's how I'd work it out, here are the applicable cases that come to mind, and you might go through your notes a bit just to double check things, and then you write it out. So I don't say this to add anxiety, it's more to give the impression that it's remarkable how little time you have, really, when you think about what it is that you're preparing for in practice, even. And the exam will be a representation of that. Somebody wants the answer immediately. So keep that in mind as you prepare. What that means is, in your preparation, maybe look at past exams. And ideally, write a question in timed circumstances. You've obviously taken exams already, but I think sometimes when you write a practice exam in timed circumstances, you get to see what it is you're not really sure about. And it really sucked to find that out in the exam. So that's why I'm saying do it in timed circumstances. That you can sort of map things out and see, well, I'm not really clear on negligent misrepresentation. I'm not clear on how that works. So you're basically testing your knowledge, how fluent you are with the language of the law in these topics. And I think that will serve you well, not just for the exam. I don't think there's really a magic to an exam, but I would say it would serve you well for practice. I know some people don't write out a plan. I would recommend it because it saves sort of the, I don't know if you've ever seen Friends exams where they have arrows all over. There's this paragraph that I really meant to talk about up here. Please read on page 10 my paragraph for page 1. And it just, I think with a plan, you think through things. And there's an internal logic to it that I think you let the momentum guide you. And we've seen things kind of flow from each other and everything. So let that plan guide you. So with a BG Checo as the overlap, you can say, well, I see these two possible claims. Here's the contract claim. I'm going to talk about breach of contract and breach of a condition. Why is this a condition, not a warranty? What are the applicable cases? Would it allow for termination? Well, is that an issue here?
No.
Are we suing for termination?
No, it's about the economic loss to be made, basically.
Right, but if we're pursuing the claim, the contract claim, this isn't a suit for you didn't perform your end of the bargain, I'm suing you because you committed what we've called a repudiatory breach. Because Checo performed the contract. So this isn't about suing for termination. They're suing for, in this one claim, the breach of the term, an express term for Hydro to do something. And you go through those cases. So keep in mind, sometimes, well, always, read the facts. understand the facts. Sometimes I find people sort of get into, they memorize, and happens a lot in the UK. People will memorize sort of patterns and will apply the pattern no matter what's on the exam page. And it doesn't work. So BG Checo is a good example in that you're not suing for termination, you're suing for breach of the term and the loss that comes from that. Now we've taken out remedies. The only remedy that we'd be looking at really is, are there damages? But we know, we've looked at for contract whether or not there'd be damages. For tort, would it be rescission or damages? Same for contract in this case, if it's misrepresentation. So go through that and then say, well, there's also a tort claim, negligent misrepresentation, and how would you go about doing that? So what's the first question we ask in a negligence claim?
Duty of care.
Right. So in negligence, we have the 4 stages: duty,
Yeah.
breach, causation, remoteness. But the first question in the duty stage,
Established or?
yeah, is this an established duty of care or a novel duty of care?
Ask for a
So what would you say here?
for the
Sure.
Checo case, or the
Yeah.
Checo case, it's a no.
Why? What was the duty?
To perform the contract.
Yeah.
To perform the contract.
Yeah, well, here's the difficulty with the overlap, right? It's hard to say the breach of your duty of care was you didn't perform the contract. Because your breach of the contract is a breach of the contract, not a tort. That's why I asked, why are they suing in negligent misrepresentation?
They didn't intend to breach the contract.
Sorry?
They didn't intend to breach.
Sure, but they're suing for what they lost in terms of the,
For economic loss, it's
yeah.
not novel, it's already established one, right?
okay.
Yes.
Well, it's a 50-50
Yes.
chance.
Yes. No, it's like from Maple Leaf Foods, we know that for pure economic loss, it's not really, it's established kind of.
It depends.
like-
Okay, so this is a good entry point to, we can apply this broadly to any negligence claim, but we'll focalize it on negligent misrepresentation. Just because it's pure economic loss doesn't mean it's a novel duty of care. Right? The novelty or the established nature depends on what?
Previous
The
we
case-
have previous case.
Case law, but how do we know what cases apply here?
Isn't it a contractual duty?
Sorry?
Wasn't it a contractual duty of care? And duty-
Is there a contractual duty of care?
The contract expresses a specific duty that these.
Obligation. A duty would be, like, the reason why I'm not trying to be pedantic more, why I'm trying to keep the language separate is, I think it's useful to learn it in this way, that there's a contractual obligation. If we talk about duty, that usually triggers thoughts of tort. And if we call it a contractual duty, my fear is that people get confused. Maybe some won't, but I'll take a more cautious approach. So when we're looking at the duty of care, what guides us as to whether or not this is an established duty of care or a novel duty of care? Sorry?
The special relationship between the parties.
Special relationship is particular to negligent misrepresentation. So it's part of the test for negligent misrepresentation. So, if you remember,
Yeah.
we have what we call the general duty of care, which is Ann's Kamloops. Then we have the psychiatric distress duty of care test, which is amended by Mustafa, which amends the 1B part, reasonable, the 1A, reasonable foreseeability in a person of normal fortitude and sensibility. Then we have negligent misrepresentation duty of care. And we have the Hercules framework, but then we had Imperial Tobacco. What was the difference between Hercules and Imperial Tobacco?
Hercules for established.
Right,
And
but
Imperial
so
Tobacco
why in
novel.
Imperial was it a novel duty of care and not an established duty of care?
Because it was not obvious who's
It wasn't about obvious.
the
The
circle.
indeterminate.
The indeterminate, yeah, it was
No,
indeterminate.
that was why they didn't find a duty of care.
Yeah.
Why, so we're still at that first question in duty of care. Why in Imperial Tobacco was it a novel duty of care, not an established duty of care?
This is because of the third party, the government.
The government.
Yeah.
It wasn't, so technically it wasn't a third party because Imperial Tobacco was suing the government
Is
in
it
this
about, like,
case.
the
Right,
prima
it was the
facie
government.
Sorry?
part, the prima facie, if it's like something that it's obvious, like clear enough, like prima facie duty, we
No.
say that this is established or
No.
not?
So you look at who are the parties. So the difference between Hercules management, who are the parties in Hercules? Hercules was one, and Ernst & Young. Oh, this was an audit in Hercules. So we have a client and the auditor. In Hercules, that was established. Then we have the tobacco companies, Imperial Tobacco, and the government in Imperial Tobacco. And that was novel. What's the difference between these two? Well, and that's what I'm answering now.
Policy.
In Hercules, it was already established that auditors owe their clients a duty of care. So you do not have to engage in the novel duty of care analysis as applied to negligent misrepresentation. But you did in Imperial Tobacco because there was no pre-existing case law where tobacco companies had sued and the courts had ruled that the government owes tobacco companies a duty of care in a negligent misrepresentation scenario.
My concern, so for
Sorry?
My concern that like for this specific type of scenarios, so we already like learned that like for the auditor has like established one, for this like it's a novel one, something like that. But in case we just like we were in for the example purpose I'm asking, like we had a
I'll tell
fact
you.
pattern and
I'll tell you.
Okay, if it's something
Hold
totally
in the
new,
fact
so how can
pattern.
we
But
know?
I will tell you.
In the fact pattern, it will say that there is no
Yeah,
case
because
law.
like how can we know?
But I'm going through this now because your question in particular raised something that seemed to be not quite as clear in the duty of care analysis, specifically with the first question. How do we know what's an established?
Yeah.
How do we know what's a novel duty of care? So I'm using the current topic to show that contrasting Hercules with Imperial Tobacco, why one was in Ann's Kamloops, if you will, and the other was Ann's Cooper. But we know for negligent misrepresentation, there's a particular test for the duty of care. So that's what the difference is when we're looking at that question of whether it's established or novel. Now, the reason why I will tell you is to abbreviate how much writing you have to do. Because let's say it's unclear. There's an argument it could be established because it's analogous. Remember when we talked about it, I used the example of naturopathic doctors. We know medical doctors owe a duty of care to patients, but do naturopathic doctors owe a duty of care? We could argue, well, they're analogous. But there's also an argument that you would, if you went to court, you would have to prepare for the novel argument as well. So for exam purposes, I tell you, because it cuts down you having to do 1/2 of that writing. Sorry?
It's possible to use care to establish.
Yeah, well, we actually, like, there are a lot of duties of care. We only look at very few here. So by telling you it's an established duty of care, for example, and this is something that came up in some comments that I received after classes, established duty of care does not mean you don't do the duty of care analysis. You engage in the Kamloops test. That's what that question is all about. Is this established or novel? We're answering that question to tell us which test to apply. So in the negligent misrepresentation scenario, we don't have Kamloops or Cooper. We basically have Hercules, which is the modified Kamloops for negligent misrepresentation, or Imperial Tobacco, which is the modified Cooper for negligent misrepresentation. Now, to give you, just to put that in context, there are duties of care for government, for public authorities, for police, for this and that. We could go on and on with different duties of care. We're just looking at 3. So when you're articling in practice, I think somebody can't get in. Sorry, could somebody at the back open the door? Somebody was, she was scratching at the window. So we're only looking at these specific duties of care. But in practice, you'd have to look at, in this relationship, doctor-patient, for example, is there a specific duty case law that tells us specific things to do with the duty of care? We're sort of looking at it, I'm giving you sort of a more generalized background than what you do in practice. So the only things you need to know are the general duty of care, psychiatric distress duty of care, and negligent misrepresentation duty of care. Knowing that in the general and the negligent misrepresentation duties of care, there's an old test, an established duty of care test, and a novel duty of care test. There doesn't seem to be a modified test for novel or established in psychiatric distress. Tamesh, you had your hand up.
For the purposes of established duty of care, is there a defined position in terms of level of precedent set and jurisdiction?
So if I could sort of clarify the question by adding some things. So if we were in Ontario and it seems as though a leading case is from the BC Court of Appeal, does that fit?
Yeah.
So it's not Supreme Court of Canada, it's within Canada, but it's not Ontario Court of Appeal. It's BC Court of Appeal. And then your question is what with that?
No, I'm asking if you're deciding a matter in Ontario,
Mm-hmm.
say at a lower level, and you want
Yeah.
to use a precedent, could you use, for the purposes of established duty of care, could you use, say, a BC appeal
Yeah.
court, and it's accepted in tier as a
Yeah,
established
so
duty of care?
what did they teach you in foundations? Like a BC appellate court decision is what? Persuasive and not binding. Whereas Ontario Court of Appeal would be binding. So that would apply here. So the BC Court of Appeal would be persuasive, but it is an appellate level decision in Canada.
So persuasive means established or not?
It wouldn't be,
Because we still have to go through the analysis and.
yeah, so again, this wouldn't apply to the exam because I tell you which test to use. But in practice, if you have a BC Court of Appeal decision that you think is analogous, at least, or establishing a duty of care for an Ontario situation, you have to prepare the ANS Kamloops and then the ANS Cooper. Because you don't know, you have to be prepared for the judge to not see it the way you're seeing it, or the other side to try to argue it a different way because they think that's better for their argument. So in tort litigation, in negligence in Canada, generally speaking, you're preparing for two tests. Unless it's clear, like a doctor-patient.
We're still following so the English old cases would be precedent, well, would not be precedent, just persuasive.
Yeah. So is there something behind why you're asking?
No, I'm asking this because established has a definite position. It's established meaning it's the nature of the law right now.
But it's the nature of that relationship between this type of plaintiff and this type of defendant. So it's just saying, we've seen this in the Canadian common law before. Courts have said there is a duty of care. We don't need to relitigate that. But if it's not clear, what I'm saying is, generally you would have to prepare for the established and the novel. Where the established is only saying, you're saying it's analogous, most likely. So my example of a naturopathic doctor compared to a medical doctor. We could say they're analogous, but there is also an argument that it would be novel. So really, the Cooper case from 2001, in my opinion, really created a lot more work for tort litigation. Because if you're on the borderline, you're preparing for two tests. But again, for the exam, I will tell you if there's to use an established duty of care or a novel duty of care for the tort questions. But to be clear again, established does not mean you don't do the duty of care analysis. It means you're applying the ANS Kamloops test. Or if it's negligent misrepresentation, the Hercules analysis. And hopefully to be even more clear, the reason for that distinction is in 2001, the Supreme Court of Canada talked about its concern that tort litigation was growing too much. So they wanted, when new scenarios for a duty of care were presented to a court, for there to be an assessment that took into consideration, should this be the case? And a good illustration of that is the Imperial Tobacco case, where the Supreme Court said there was a prima facie duty of care owed by the Canadian government to Imperial Tobacco. But at that second policy question, the more generalized policy question, the Supreme Court said that there should not be a duty of care recognized in this scenario because it would lead to an indeterminate liability. So, some people are visual learners, so it might be worth sort of visualizing how that works. That's why I said the first question is it an established or novel duty of care? Then you kind of have these two branches. Yes, no. And then you go off into different steps depending on them. But everything starts with that first question. Is this an established or novel duty of care?
But you said you will provide us with the
Yeah, yeah, I will tell you.
The kids.
But I'm still reiterating how it fits in because my impression is that this seems to be a bit of a cloudy area for some. So now that you're ready to write the exam tomorrow and feel really good about things, let's look at, let's put aside the contract tort overlap and go to contract. So I have 7 o'clock. We'll take the break about 7:30. But let's take this half hour and maybe talk about things that are unclear in the contract for you. Remember last week I had asked you, please bring questions for Monday. This is the Monday questions. Now, so are there things that are unclear about contract? I could just fire off questions if that jogs your memory.
And the most important one.
No, I usually start with the really redundant ones. Formation of contract. What are the elements of a formation that we're looking for?
Offer and acceptance.
Offer, acceptance.
Consideration.
Yeah, consideration. Intention to create legal relations. What does certainty mean within that?
Has to be certain.
Oh, good. Could we elaborate a bit on that?
To make it clear, like what's the consideration?
What is it? What is clear?
The terms should be clear that what's the, like the element, like for example, what's the price or what's the consideration is, what's the obligation of the parties exactly, like all
Okay.
those things.
But, Ebra?
The period.
So it's going to be that the acceptance must like mirror the offer.
Okay.
Yeah, so we have that to be sure that we are accepting that exact offer from the other party.
Okay. Yeah. So we have mirror image, what we've called mirror image. That focuses on offer and acceptance a bit more than certainty. And that is speaking to whether or not it's clear that the offeror and the offeree are offering and accepting the same thing. Certainty gets into these sort of what we might look at as secondary points, some of the key details. So remember the cases. We had May and Butcher as one of the first ones that we looked at. And that was the case where May and Butcher were purchasing tents from the First World War from the Crown. But the House of Lords, that agreement was found to be void for an absence of certainty because it wasn't clear several things weren't clear. One was the price. One was, another thing was how much would be purchased, when, things like that. But then we had the Hillis and Arcus case and the Foley versus Classic Coaches case. And in those cases, the price was left to be determined. And we talked about that.
But there was previous dealings in those cases between the parties.
Yeah,
That's
that was
why-
one point.
Yeah, and.
So it was the
there's a
difference
system
between
how to-
executed and executory contracts. So May and Butcher was to be executed, executory. Hillis and Foley were executed contracts, meaning that they were contracts of a couple of years at least, where at least 1 year had been performed.
And also there was the system how to determine the price, so.
Yeah, the dispute resolution aspect, we might call it, as to how a fair market price will be determined. So this is what we're looking at with certainty. We may have offer and acceptance, but is it certain? Assets are secondary details that are equally important. So while formation has 4 elements that we named: offer, acceptance, consideration, and intention to create legal relations, certainty is a factor in that analysis. And if you recall, I gave you the clause from the contract from the UK regarding the steel mill that had that could have been triggered around the time of the beginning of the Great Recession. And we talked through how that would apply. So that's formation. Why is formation so important to courts?
Because if court finds that the contract was not formed at all, then there is no contract question.
And there is no contract, but remember, yeah,
Because,
Shows the intentions of the parties in formation stage.
yeah,
because like once the
go ahead.
once the contract has made, the court will try its best not to set aside the contract if it's like clearly not like formed contract.
Yeah.
I basically want to say the same thing.
Also the interpretation of the terms.
The court will try to preserve the contract as long as it's.
So the emphasis is placed on formation. Remember some of the offer and acceptance cases we looked at. The emphasis is placed there, or courts scrutinize the formation of a contract a bit more, because they say, we want to make sure that it was clear what the parties were agreeing to. Because once that is established, courts are highly unlikely to let people out of agreements. That's sort of the philosophy of it. We can see examples where that doesn't quite fit, but the general approach is we want parties to use the instrument of a contract, and that will be upheld in courts. So then we went to what we might call the content of the contract. And we have incorporation of terms. What was incorporation of terms about?
Whether it's condition, warranty,
No. That'd be the interpretation. But incorporation of terms means what?
Okay, if the condition or term like fundamental to the contract, and it's just.
No, that's still
It's not
that's
the
still interpretation.
yeah.
Terms that are in common use in a certain situation used to.
No.
So we should have a long contract, so if there is like 20 pages, means that the parties
quite. So incorporation is talking about the terms of the contract that are being argued about or relied upon. Were they actually incorporated into the contract?
Yeah, the
What
previous
were
negotiation.
the terms? So here we have ideas like the parole evidence rule and an entire obligations clause that say the entire obligations clause we saw last time, which says this written agreement contains all the obligations between the parties, and anything orally represented is invalid.
Yeah, this is rubbish.
Yeah. So the idea here is, even once we have formation, parties can differ as to what went into formation. Another example is, if you remember the parking lot case, Thornton versus Shoe Lane.
Exclusion.
Yeah, that was about the exclusion clause, but the first step was,
The contract was formed when he entered the parking lot.
Yeah.
And got the parking ticket. And the fact that the exclusion clause appeared later when he parked the car and saw it on
the wall.
The court said that this term was not incorporated at the time of the formation.
Right. So Thornton and Shoe Lane is a variation on this incorporation idea as to what were the terms that were agreed to between the parties at the moment of formation. Specifically in that case, it was whether or not an exclusion of liability clause had been incorporated. But the issue precisely was incorporation. Was it part of the contract? And this involves a bit of interpretation, but not to the extent necessarily that we had looked at before. Because with interpretation, what did we look at? We looked at things like express terms and implied terms. We looked at how terms are classified. Warranty, innominate term, and condition. These are getting into the details of the interpretation of the contract. What was an express term? What's implied? What is a fundamental term? What is a breach of a condition versus a breach of a warranty? That's what we're looking at with the interpretation. And then we had some things like the canons of construction. So the three classifications that we had told us what about conditions and warranties in particular, because innominate terms are basically terms that the parties have not spoken to directly and could be either conditions or warranties depending on the interpretation by the court. So how do we distinguish between conditions and warranties?
When you do conditions, you're looking at the root of the contract, which is essentially the substantial factor of the contract itself, information. And usually when you're distinguishing between the different terms, we're pretty much looking at the remedial approaches.
Yeah. So when we're looking at, is this a breach of a condition or warranty, it is telling us what steps to take, what steps we think we should be taking in terms of redress. If it's a breach of a condition, the innocent party is arguing that the defendant, as it usually is, committed a repudiatory breach, repudiated the contract with their conduct. And so the innocent party is going to sue for the benefit they would have had the contract been performed. A warranty breach says, well, it isn't so significant that it would repudiate the contract, but it does allow the innocent party to claim damages because there was a loss. The contract remains in existence, but a term has been breached. And with that, we sort of have this question of, well, how do we know which one is which? And that's where I suggested we have the Hong Kong Furs case that guides us. Because in the Hong Kong Furs case, I know these weren't the precise facts, but Hong Kong Furs had lost about a quarter of the time with the ship it had rented in a 2-year ship rental. And Hong Kong Furs says, well, if I can't use it for that amount of time, that is a repudiatory breach. And the Court of Appeal, later he became Lord Diplock, said, no, Hong Kong Furs could only claim damages for breach of a warranty because they were not deprived of the substantial benefit of the contract. So we see with Hong Kong Furs that to get to the threshold of a repudiatory breach, where it's a breach of a condition, takes something extra. You have to be deprived of the substantial benefit of the contract. And if you think that's a vague term, it's meant to be. Because it's meant to be a term that can be applied to a variety of situations. The guiding case, I would suggest, is obviously Hong Kong Furs, where it says, well, having lost a quarter of the time was not being deprived of the substantial benefit. Theoretically then, if you lost more than 50% of the time, more than a year of the use of the ship, arguably that at least gets you closer to being deprived of the substantial benefit of the contract. So it's kind of a high threshold, it seems. And if you recall, I asked you, how would you advise a client? And I suggested this was an important question because if your client says, this is a repudiatory breach, I can sue for termination, and they insist on that, they're taking a gamble that they themselves are being put in the position of breaching the contract. If the court says, well, this is only a breach of a warranty. But what you did was you ceased performing your obligations, therefore you're in repudiatory breach, and you owe the other side damages on that level. So it's a very important strategic question whether or not you're going to look at repudiatory breach in certain circumstances because of the consequences that go with it. And then, sort of, because things weren't really complicated enough, we have the case of Bazin, which brings us the idea of good faith. That once the contract is formed, there can be a breach of an obligation to perform in good faith. And I flagged that in particular for this class because many of you come from civil law jurisdictions where good faith, depending on the jurisdiction, can be a forceful argument. In the common law, it is not as forceful. It is a newer, developing area. And It's unclear what is being done with that. We read the case from the Ontario Court of Appeal from late last year, I think it was. And I noted to you that this Ontario Court of Appeal case and the BC Court of Appeal case are being heard by the Supreme Court. So there will be another decision, hopefully a clear one, about good faith in contract. But it means, for now at least, that there's always this potential argument, perhaps, that we keep in mind. So that's the content of the contract. Then we have this category of topics called vitiating factors. Vitiating factors means that at the time of formation, generally it means, at the time of formation, something went wrong. And the parties were not agreeing to what they thought they were agreeing to, or something happened during the course of the performance of the contract beyond the parties' control, such as a frustration of the contract, an act of God, as it's commonly called. So we saw one example of a vitiating factor, or at least the argument of a vitiating factor, in the Williams and Rolfe brothers case, which was about consideration. In that case, the argument was put forward that there was economic duress. What is economic duress? Sorry? Yeah, unless you, there's some sort of financial gain, basically, it seems.
It's kind of like, if you don't pay me more, so
Yeah.
I'm not like performing the.
So the case of NAV versus the Fredericton Airport Authority was a case where we saw this successfully litigated. That economic duress was successfully argued, that the Fredericton Airport said, we only agreed to buy this new equipment because NAV threatened not to provide us with electronic services unless we bought this. And we need electronic services, which are essential for our work at the airport. Another vitiating factor is unconscionability. What I'll say is that would not be the primary, if it's on the exam, it would not be the primary argument because it's the subject matter of your essays. So why I say it wouldn't be the primary argument, why I'm saying that is, if you feel in an exam that you can make that argument, I don't want to close that off for you. But it would not be the focus of a question. So put simply, I wouldn't give you a question where unconscionability was the most likely argument. And that's what we covered for contract. Did that jog any questions?
So I have a question. So usually like the interpretation of the contract, like in what type of like questions we can do?
Well, so that was, for example, is it a condition or warranty?
Yes, but your question will be directly like, is this is this a condition or warranty, or within some analysis, we have to like touch to this thought? This is my question.
So let's take Hong Kong first.
Yes.
How do we get to the classification of terms being the issue, which is a subset of interpretation in Hong Kong first? Why was that the issue? If my question isn't clear, let me know.
Yeah.
Sorry?
Because if it's like condition, so it can end up with the termination of the contract, or if it's warranty, so it doesn't trigger.
Right, but how did we end up there? So in Hong Kong first, how do we get to the point that the classification of the terms was the legal issue in the case?
Because claimants want to get out of the contract because the job of the like price not.
The last part I didn't quite hear. The price?
That there is a rate drop in the market, so that the higher want to get out of the contract. This is that.
Yeah, it wasn't just that. If it was that simple, it'd be a bit of a different case. It's also because they couldn't use the ship.
Well, that's the factual pattern.
Yeah.
Actually, the contract was between the owner and the charter, and the charter wanted to have a charter ready on a particular day, particular moment. The owner wasn't capable of delivering because the boat was getting fixed. I forgot the facts.
Yeah.
It's about the facts, and then the charter said, "I'm out of this because I have no use of it."
Yeah, so after a period of time, the charter party, the one renting the ship, had to wait so long that they said, well, this 2-year contract, you're not performing
5 months.
what you should have. So you have brought this to an end. So within those facts, we got to the classification of terms as being the primary issue because it was a question of, well, what, as the Court of Appeal said, what was being deprived of the substantial benefit of the contract? What did that mean? And in that case, it was found that the innocent party had not been deprived of the substantial benefit of the contract. And that question was important because it was a question of, well, what term was breached and how important was that term? And if you recall, when I first talked to you about it, I asked you, put yourselves in the position of the charter party. You sign a 2-year agreement, and all of a sudden you can't use the ship for a quarter of the time. I think to anyone in that situation, you'd say, contract must be over. Like you're not allowing me to use the ship. I can't use the ship. The contract is done. But that's not what the Court of Appeal said. That went to the classification of the terms. So, to sort of reiterate a bit, how do you identify what the legal issue is? Well, you have to get through what do the facts tell you the legal issue is. In Hong Kong first, the legal issue was the importance of the term breached. So as an interpretation of the contract issue, specifically the classification of terms, condition versus warranty. So I think when you're preparing, it's useful to take a look at some of the cases, the facts of the cases, which I've always gone through with you, because that tells us why the court came to this point being the legal issue. And that's just a way of sort of practicing how to identify the legal issue. Yeah.
So I have 2 questions. Just to make sure, even if we have a termination clause in the contract which says that in case of the certain breach, the other party is entitled to terminate the contract. Still, the court will engage in the interpretation of the whole contract.
Yeah,
Okay?
because we've seen cases where they say, just for everybody's benefit, the termination clause can say when X happens, the innocent party can terminate the contract. But we know from the case of Schuler, for example, that that is not definitive. Courts will interpret the contract, and we saw a couple of cases where the innocent party was trying to terminate the contract where something rather innocuous or not quite so serious happened. Like, I think one repair wasn't done out of many in a year-long contract. That would be insufficient. So the courts, going back to Hong Kong Furs, will not allow people to terminate a contract for an overly technical reason. Like one missed meeting out of 100.
Bettini is the same, yeah?
Bettini was a bit different. So Bettini was sort of the forerunner to this discussion of interpretation and classification of terms. Bettini and Guy was the case about the singer who arrived 6 days late for rehearsals, and Guy said, "You're out." It was a 4-month contract. Bettini was there in time to perform the performances for 4 months. But Guy said, "Well, you're supposed to be here for about a week's worth of rehearsals. You weren't. I'm terminating the contract." And the court said, "You can't." Because that was not, and this is where we get sort of this, I think it's a bit misleading language, this idea of, well, didn't go to the root of the contract. The reason why I say I think that's misleading language is because of what we talked about with Hong Kong Furs. If I can't use the ship for a quarter of the time, doesn't that go to the root of the contract? But the court said you have to be deprived of the substantial benefit of the contract. So it's a higher threshold. And you had a second question.
I don't remember the name of the case. There was a case where the safe was late for some days. They arrived 1 week late.
Yeah, it was a shipping case.
Yeah, and this case with the Hong Kong case, like how can we reconcile this case? Because in the Hong Kong case, we have, for me, it seems like a pretty, like 1/4 of the rental time. I'm deprived of 1/4 of the rental time. It seems to me serious breach. And then we have another case where the ship did not arrive exactly on that date, and this was considered a repudiatory breach.
Yeah.
And when a client comes over in the exam, so we can yes present both possibilities, like both cases inform us of what could go in which direction. But finally, I cannot give. In a lot of cases, I think we can not be say it's possible that or the other. I cannot say in the end of the scenario that this is more likely, or because for me they're so, I don't know. I found them very different. These cases.
And we'd actually talked a bit about this, and I said that these cases give you a range or scope within which the courts will decide. So the case you're referring to, where the ship was supposed to be ready for the charter party on the 1st of June, I think it was, but it arrived on the 14th of June. And the court said, well, it wasn't there by the 1st of June. You repudiated the contract. And I mentioned at the time, I think I was surprised by that because there's a very technical reading. Also within the shipping context, there's a bit more leeway usually given. But the courts can decide that way. The question would be, how likely would it be based on the facts?
Or how do we advise a client?
Yeah, that's what I'm talking about. So you can say, well, Hong Kong Furs talks about the being deprived of the substantial benefit of the contract. Here, the question is, was the innocent party deprived of the substantial benefit of the contract? Here are the arguments. I think it would be more likely this way, and here's my reasoning. So you don't have to be mathematical, so to speak, about it. You don't have to have the answer. You're giving your advice. And I think within that range of, I think the case was the Bunge versus Tradex. Within the range of Bunge versus Tradex and Hong Kong Furs, we have a spectrum within which we can advise clients and say, this is a spectrum within which courts will decide. Based on your facts, I think it seems as though the courts would go this way, and that can be your advice. Does that make sense? Or?
Yes, but I practically think I could not reach this conclusion based on your facts, because they seem to me opposite. I see a very some days delay, and that this is considered as a, so I cannot see when I can find a fact that it's more similar to the one case or the other case. When
well, I think part of the thing would be keeping in mind the facts. So if the facts are closer to Bunge, that may well be the way the courts go. So like the principle would be like cases should be decided alike. But we know there's this very powerful mechanism of distinguishing cases.
And for exam purposes, can we just state how the courts have applied the testing, the range, and not reach a conclusion?
Yeah, you can't, you're not telling people, do this. You're advising, you're saying, the court may go this way, but we have to keep in mind there's a risk, and here's the risk. So I think your question is about phrasing your advice as opposed to anything else. Because you're not saying, do this. Not like in any advice, and those of you that have practiced can reinforce this. You never say, do this. Because if it turns out not to be the way to go, you get sued. It's always the client's decision. You're just laying out basically the risk involved. So I think people really want a break. So I have about 7:35, so we can come back at say about 8. And in that extra bit of a break, if you want to ask me some questions during the break, you can.